This is Barry Zalma on insurance. I am an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness and author and producer of these videos. Today, I'd like to talk about the need for an insurance company to make a decision to defend or not defend an insured who presents a claim for a construction defect or has been sued claiming a construction defect. Insurance, to the general public, is considered a quasi-public utility, since modern industry and business could not effectively operate without it. The courts recognize the importance of insurers to the community and therefore find a need to more stringently control the actions of insurers. As illustrated by the California Supreme Court decision in Egan versus Mutual of Omaha, adjusters must always conduct a thorough investigation of every claim before making a decision to deny, or the insurer will find itself forced to pay claims that are not covered because a court concludes the insurer acted in bad faith. Further, insurers can also be assessed a fine by the state's Department of Insurance for breach of the Fair Claims Practices statutes or regulations. Some of the more difficult cases where the issue of should we defend or not are cases where patent infringement is alleged. Insureds accused of infringing patents that are incorporated into the structure of a product will often make claim on their commercial general liability policy for defense and indemnity, claiming that patent infringement is an advertising injury covered under the personal injury coverage portion of the CGL. As a subset of the personal injury coverage for advertising injury, patent infringement claims are presented with greater frequency since the decline of .com industries and the growth, again, of .com type industries like Amazon.com and the consumer electronics and computer industries, because defending against a claim of patent infringement requires a specialized team of attorneys, designers, and engineers. The cost of defense is often extensive, and the infringer is highly motivated to find a way to gain coverage for the alleged loss, claim, and suit. Regardless of the motivation, success in obtaining coverage is not necessarily easy. For example, in Weiss versus St. Paul Fire and Marine, a 2002 decision of the Sixth Circuit, the court said the plain meaning of an advertising injury defined in the policy as piracy and unfair competition does not arguably cover the losses due to patent litigation, and therefore St. Paul had no duty to defend in the patent infringement litigation. Infringement of title, on the other hand, when read in the context of the policy, may not be construed to apply to claims based on infringement of legal ownership rights to property. Hence, a reasonable layperson would not expect a claim for patent infringement to be covered under advertising injury offenses of the CGL policy. Since there is no potential for recovery under a policy for a charge of patent infringement, there is no duty to defend in the courts of the California Supreme Court, which decided Bus versus Superior Court in 1977. In Green Machine versus Zurich American, the Third Circuit in 2002 found no duty to defend a patent infringement claim where it was alleged that the insured made a concrete cutting machine in violation of another manufacturer's patent. The court stated that advertising injury is not, however, the same thing as advertising per se. Advertising injury is the misappropriation of another's advertising idea or concept. Green Machine argued that Chiumanata's advertising concept was not to solicit its relevant market to cut concrete using its patented method. Thus, Chiumanata's advertising injury, which Green Machine contends it was accused of misappropriating, was to advertise. Under this theory, any competitor of Chiumanata's who advertises, no matter what the content of that advertising, has misappropriated Chiumanata's advertising idea to advertise. This is not what we mean by advertising injury, since where the meaning, there could be no advertising without injury. Allegations that Green Machine stole a patented method for cutting concrete and also advertised the results of that theft does not convert the underlying theft into advertising injury as covered under a CGL policy. The construction, especially the construction of dwellings, requires the owner or developer to conduct serious and widespread advertising if the dwellings are to be sold. If that advertising infringes on someone else's ideas or name, it can involve the CGL. For example, consider a competitor who has built a highly successful tract called Olive Tree Acres and sold 10,000 homes in Olive Tree Acres. If a builder who builds a 200-unit condominium in the same area and advertises it as Olive Tree Acres Condominium, the originator may sue for infringement. The developer of Olive Tree Acres Condominium may in turn seek defense under its own CGL. In Palmer versus Truck Insurance Exchange, a 1999 decision of the California Supreme Court that found there was no coverage under the CGL, and stated, in this case, we consider whether certain insurance policy provisions relating to advertising liability caused by title or slogan infringement cover infringement of any name. Interpreting the relevant policy language in the context of the policy as a whole, we hold that these provisions only cover infringement of names of literary or artistic works or names that are slogans, and no other names. The California Supreme Court refused to expand the coverage, however, to misappropriation of a slogan or other name. A slogan, it's understood, was a brief, attention-getting phrase used in advertising or promotion, or a phrase used repeatedly as in a promotion. The infringing use of a trademark, that is merely a word in a phrase used as a slogan, is not the same as the infringing use of a name. The slogan, "Good to the last drop," is identifiable to a certain product because of its extensive advertising. It is different, however, than the use of a name like IBM. To obtain coverage, the developer would need to show he not only infringed on the Olive Tree name, but also used exactly the same advertising techniques used by the original developer. For coverage to exist, it must be inextricably tied to the advertising actions of the insured. On the other hand, applying Florida law in Hyman versus Nationwide Mutual, the 11th Circuit in 2002 found coverage for trade dress infringement, that is, the act of looking like someone else's property or product. Trade dress infringement may, under certain circumstances, constitute a misappropriation of advertising ideas or the style of doing business. We note, however, that it will not always do so. Rather, for the injury to be covered under the policy, the trade dress at issue must constitute an advertising idea or a style of doing business, and it must have been misappropriated. If, for example, a developer built a Sam's pancake restaurant in the same style as the blue-roofed A-frame structures used by the International House of Pancakes, the developer may find a suit from IHOP for misappropriation of its style of doing business, as would Sam, the owners of Sam's Pancake Restaurant. One cannot be said to have misappropriated advertising ideas or a style of doing business when it is the shape and appearance of the product itself that is claimed to have caused injury. The prudent property owner will keep detailed records concerning the structure, the construction, or acquisition of the structure, and all advertising done to lease the structure to occupants. Similarly, the builders, subcontractors, and design professionals will keep the same records to make more readily available their rights of indemnity under their own CGL policies if they become a defendant. Records to retain include, but should not be limited to, the following: all contracts with advertising agencies, copies of all print ads, videotape of all television ads, audio tapes of all radio ads, or drafts of all advertising. The record should be maintained for the amount of time available to sue under the longest statute of limitations or statute of repose available to the plaintiffs, plus 1 year for safety. In addition, coverage issues arise and must be resolved with regard to copyright infringement claims, trademark infringement claims, or claims of faulty workmanship, among other issues that are covered in detail in my book, from which this video was adapted, Construction Defects and Insurance, Volume 3, which is available as both a Kindle book and a paperback from Amazon.com, with details from my website, Zalma.com, by clicking on the link to the Insurance Claims Library, where you can learn about all 8 volumes of my book on construction defects and insurance. If you found this video to be of use to you or of interest, please refer it to your colleagues. It's free. And please subscribe to my YouTube channel, my Rumble channel, and my blog so that you can be informed of future videos and blog postings about insurance and insurance claims matters. Thank you again for your attention,